Hello and welcome to another segment of Good to Know Family Law Topics. Today I'm going to discuss with you the process of dissolution proceedings. And the reason why I'm going to talk to you about this is many people who come to see me are very confused and a little bit frightened about what the process is. By explaining to you the three main phases of a divorce, you're going to have a lot less stress and hopefully you'll be in a position to better strategize. So let's talk about that first stage. The first stage is what I like to call the information stage. And that's where you're providing notice and opportunity to the other side. The petitioner files a summons and petition and serves it on the respondent. The respondent within 30 days has to file a response. And this petition is basically telling the other side and the court what you think that this case is about and what, if anything, is going to be contested. Now, within that very beginning of the case, which I call the information stage, there's also a requirement that both sides prepare preliminary declarations of disclosures. A preliminary declaration of disclosure is a schedule of assets and debts and an income and expense declaration that lays out all of your assets and debts, whether you think they're your separate property or your community property. And the reason for this is that both parties have fiduciary duties toward each other, and it's important that we know what we're going to be talking about later on, either at a settlement conference or at trial. Now, the second phase is what I like to call the discovery phase. And this is where we're trying to figure out what the case is all about and also to work up the case. And when we talk about discovery, we're talking about things like sending out subpoenas, asking the other side to produce documents, taking depositions, and a variety of other things that require investigative tactics in order to build a case and understand what the case is all about. And the final stage of a divorce proceeding is what I like to call the resolution phase, or sometimes I call it getting to the finish line. And how do you get to the finish line of a divorce proceeding? Well, there's only two ways. One of them is going to be through a trial. The good old-fashioned trial, an evidentiary hearing at the end of the case that requires calling witnesses and putting on evidence. The other way is the settlement process, either voluntary or mandatory. What you should know is that 95% of all family law cases settle. And it's just a question as to at what phase a case settles. Now that you know about the three phases of the dissolution proceedings, let me leave you with one last tip. And the tip is that don't think of these three phases as rigid. One doesn't have to come after the other. In fact, there's a lot of overlapping that occurs in a lot of divorce proceedings. And if you're lucky, you could get to the resolution phase very quickly, either before or contemporaneous with you filing your summons and petition. You could have the resolution of your case etched out if both sides are in agreement, and you'll never have to go to court. You can simply prepare the paperwork and submit it to the court for the judge's signature. Thank you again for joining us on Good to Know Family Law Topics. Be sure to read our blog and to look at our YouTube channel to learn more about important family law topics.